And now to help us understand the significance of this Supreme Court ruling on same-sex couples and property rights, we're now joined by family lawyer Attorney Sol Mawis. Good morning, Attorney, and welcome to Morning Matters.
Good morning, and thank you, Mayor, very much for inviting me. Thank you.
Okay, so Attorney, let's break down this latest ruling by the Supreme Court for viewers who may not be lawyers. What exactly did the Supreme Court decide in this case involving a same-sex couple, and how significant is this ruling?
It is very, very significant because for the first time, the Supreme Court recognized that notwithstanding the fact that we cannot have same-sex marriage because there is no law allowing that, at the very least, the Supreme Court recognized that if a same-sex couple acquired, properties, each of them will have some kind of protection with respect to their property relations. And so this is very important.
So this case involved two partners who lived together. They bought a home and even agreed to register it under just one name for convenience.
Yes.
And when they eventually separated, that's when the dispute began. Attorney Sol, do these instances happen often here in the country?
Yes, normally because of trust, maybe trust and confidence, and out of love, of course, you trust this person who will just register the property under her name, notwithstanding again the fact that he or she actually contributed to the acquisition. And then later on, when love fails, and stops, that's where the problem starts. But we must understand that when we talk about under Article 148, Article 148 covers situations where the marriage is void from the very beginning, or the couple live together as husband and wife without the benefit of marriage because there exists a legal impediment. And in this case that was recently decided by the Supreme Court, there was a legal impediment. They cannot marry because they are of the same sex. And for that, Article 148 provides, the rule as to how the properties will be divided. So Article 148, under Article 148, the properties acquired during their cohabitation as husband and wife can be considered as common property. Okay? But of course, there are requirements that must be complied with. Number one, the property must have been acquired during their cohabitation when they live together as husband and wife without the benefit of marriage. And number two, there is evidence that the properties were acquired through their actual joint contribution of money, property, or industry. And such contributions and corresponding shares of the parties are prima facie, presumed to be equal. Now, however, for this presumption to arise, there must be proof of actual contribution. Unlike in 147, we are talking about 148. In 147, the marriage was declared void, but not because of a legal impediment. Example, the marriage was declared void because of psychological capacity under Article 36. You don't need a proof of actual contribution. In fact, the care, the maintenance, and household of the family will be considered as the actual contribution of the partner. But in 148, it's different. You still must have proof of actual contribution. And in this case, the proof that was shown, the evidence that was submitted to show at least actual contribution is actually the acknowledgement that was executed by the respondent, wherein she acknowledged that her partner contributed, and contributed at least 50%, on with the actual contribution is 50% representing her contribution in its acquisition and the construction of the improvements introduced in the property. And that's the reason why here the Supreme Court said, this property therefore is co-owned.
Attorney, what if the contributions weren't equal between the two parties? How would that change the dynamics of a case?
It will still be considered under the rules of co-ownership, and in relation to Article 148, they are still co-owners, but the ownership will be will be limited to one's actual contribution. But in the
Okay.
absence of actual contribution, but there is a recognition that there's contribution. Okay, still that the presumption will be it will be 50-50. But if there's evidence to show that it's actually 60-40, then the co-ownership will be 60-40.
So, but there's a presumption of equal contribution.
Yes.
Okay, but attorney, in real life, couples don't always keep receipts or all these acknowledgement documents, right? So, what kind of proof should couples, especially same-sex ones, keep to protect themselves?
Well, number one, of course, will be your receipts, no, to show actual contribution. Number two will be, like in this case, a written acknowledgement that there is actually co-ownership, an affidavit which can be used against any of the co-owned or any of the partners. Third, in other words, there should be a paper trail. Okay, you cannot just go to court and say I co-own. There must be paper trail to back up your claim that you have actually contributed, because it's actual contribution. Paper trail is very important.
And attorney, well, would you consider this a landmark ruling in terms of recognizing the rights of same-sex couples, or is it more of a clarification of an existing law? Because this decision was heavily anchored, as you mentioned, on Article 148 of the Family Code. But does this decision also create any new rights, or does it just clarify something that was often overlooked before?
With all due respect, it's not a clarificatory decision. It is really a landmark decision as far as I'm concerned. Because this is the first case wherein the Supreme Court recognized that Article 148 applies to same-sex couples, okay? And it is a recognition that even if they are not married, they have property rights. And that's the reason why, to my mind, this is a very important and landmark decision.
But at the same time, attorney, the Supreme Court was very clear about its limits, saying that they cannot grant the same bundle of rights as marriage. And the broader solution there must come from Congress. For you, attorney, what are some of the protections that are still missing for same-sex couples despite this ruling from the Supreme Court?
Of course, the validity of their union. We still do not have any law that would allow and recognize same-sex marriages as valid, because under Article 1 of the Family Code, it is clearly stated there that marriage is between a man and a woman. So that is very important. Why? Because if they are not technically legally married, if one of them dies, then the other one does not have any successional rights. If the person dies without a will. Of course, it's different when the person dies with a will. He or she can very well put a stipulation in the will, giving something or bequeathing something to the other couple, no, the surviving couple. But without that, if one of the couples one of them dies, okay, then the problem is, okay, the other surviving one would not be considered a compulsory heir. So number one, I think, is whether it is high time that we should recognize, same-sex marriage as a valid marriage.
But attorney, are you optimistic that this decision from the Supreme Court could eventually open the door to, of course, the broader recognition of rights beyond property of same-sex couples?
I think so. The Supreme Court was open enough to discuss and for the first time, define exactly the property rights of same-sex couples. Maybe, but of course, it's just the Supreme Court applying Article 148. There is a law. Now, and the Supreme Court is very right. The Supreme Court cannot just simply, apply all the rights and privileges accorded to a legally married couple. There must be a law first that would allow and recognize the validity of the marriage of same-sex couples before they can, apply all the rights and privileges that are accorded to heterosexual unions.
And at the same time, well, several justices, including Justice Leonen and Ami Lazaro Javier, emphasized that same-sex relationships are normal and that they should not be legally invisible. In your personal opinion, attorney, how important are these statements? I mean, were you even surprised with what they said?
I'm not surprised at all because it's really true. I mean, there exist couples, okay, who are of the same sex. There are a number of couples I know for a fact that they have been together for more than 50 years and they're still together. So to me, as I said, this is something that has been existing for quite some time. It's about time, okay, that we should more or less recognize their rights. And this is the first step to recognition, to my mind. This property relationship. If this, at the very least, if Congress cannot pass a law at this point in time to legalize same-sex marriage, at least a couple who is into that kind of relationship will still be protected. Okay, insofar as property relationship is concerned.
Now, after this ruling, the Supreme Court, attorney, practically passed the ball to Congress here, urging them to pass laws for same-sex couples. But in your view, what kind of law is most urgently needed to address this legal invisibility that we're calling and that the High Court talked about?
I think the amendment to Article 1 of the Family Code, which is not limiting the marriage, okay, between man and woman only. If there is one law that can be reviewed and can be amendment to address all these concerns regarding same-sex union, will be Article 1 of the Family Code. That will be, I'm very sure there will be so much debate on it.
And for you, attorney, what are some of the risks that remain for same-sex couples as long as there is no specific law governing the relationships?
Again, it's more of successional rights. If one of the couple, okay, one of them dies ahead of the other, then that person dies without a will. The surviving partner will not be able to inherit. That surviving partner will not be considered a compulsory heir because they're not married at all. Okay?
And do you see this ruling, attorney, influencing how lower courts will handle disputes involving same-sex couples moving forward?
Yes, ma'am, because the lower courts are bound to follow the decisions rendered by our Supreme Court because the decisions of the Supreme Court form part of the legal system of the Philippines.
And finally, just as a last question, attorney, how big of a win is this ruling of the Supreme Court, especially for the LGBTQ plus community? And but what still needs to happen from this point, especially if we want lasting legal protection for this community?
Okay, it's a very big win. As I mentioned earlier, to my mind, it's a landmark case because it gives now recognition that same-sex couples, okay, have property rights. Okay, they are in fact, but with this decision, the decision basically tells the couples of what to do in order that their property rights will be protected. Now, but this is just the first step. For the LGBT community, okay, of course, they need, okay, to make sure that the law will be amended accordingly, or at least a new law will be passed to recognize their relationship as valid and binding.
All right. Well, thank you very much for helping break that down for us. That was Attorney Sol Mawis. Thank you very much, attorney.